Hi, my name is Austin, and I'm one of the members of the Right to Vote Committee. And I'm speaking with our attorney, Tom Scroggins. Tom has been practicing labor law for over 20 years. We talk about how we got here today, also about the bogus neutrality agreement USW has held everyone hostage over. So please, join us. What's going on, Tom?
What's up, Austin? How are you?
Thanks for coming in, man.
Oh,
I appreciate you traveling down here and being able to sit down and answer some questions with us and go over our Right to Vote Committee meeting.
oh, my pleasure. I mean, you finally get a vote, right?
Oh yeah, no, we're getting a vote. Yeah, we're definitely getting a vote for sure. It's going to be on the 24th and 25th.
Unless the union blocks it again.
Yeah, you know how they like to do that.
I mean, it's been on and off and on, but I think you finally got them whooped.
I mean, how
At
did
least
we?
as far as getting a vote,
I
anyway.
mean, how did we even get here to this point? I mean, honestly, what has it been like 14, 15 months?
Uh, depend.
I've almost lost count, honestly.
Well, it kind of depends on who you talk to. So officially, the union says they started their campaign in January of
Yeah, but we know
2019.
they started in October.
Yes, because how do you know that, Austin?
How do I know that?
Yeah, how do you know that?
Just from talking, just the talk in the mill.
And the fact that they were holding employee meetings in October.
Yeah, yeah, absolutely.
Yeah.
Yeah,
So,
yeah.
officially, if you can believe what the union says, they started in January collecting cards, but it had been going on a little bit before that. They've been testing the waters.
Yeah. Well, how or why didn't we get a vote at the beginning? Originally, like how everybody was like, just assumed that we were just going to have this vote, and they came in with this card check process. And I mean, like, how do you deal with that? Have you in all the times that you've seen unions come into mills? Because I mean, you've dealt with this. You're a labor lawyer, and you handle such issues as this. So,
Right.
how unusual has this actual campaign been versus the ones that you've seen?
It's been extremely unusual. So, the normal process that most people, most employees, most of your coworkers are familiar with for a union to come into your plant and interject themselves into your work life and is through a secret ballot election,
Yeah.
and that election would be supervised by the National Labor Relations Board, which is a federal government agency. And normally, the way that works is the union would have to collect at least 30% of the workers' signatures on authorization cards.
Now, is that organically for them to do that? They have to do that organically outside of the mill.
Normally, yes, that's a good point. So normally, union organizers are not inside the mill like you experienced last year. They get those outside. Now, their supporters who are employees, they may solicit union cards, signatures on union cards inside the workplace. But paid union organizers are typically not allowed inside a mill like you had for 6 months last year.
Right.
They're typically not allowed to sit in break rooms for 6 months like they did last year while everybody's in there trying to eat their meal in peace and quiet.
God, I couldn't
You
stand
remember that?
Yeah, I couldn't stand that.
Did you enjoy that much?
No, I didn't. I didn't enjoy that at all.
Yeah, I don't think many of your coworkers enjoyed it either.
No, no. But
So,
I mean, they pretty much gave us a heads up about what was coming. I mean, as far as like with the neutrality agreement talk that they had us go through, the company educated us on the neutrality agreement. And at that point, I realized I was like, this is not right. This doesn't seem right.
it's not the normal method. So so normally you have this secret ballot election. The union gets 30% of signatures on cards, and then they can file. Once they get to 30%, that gives them the minimum amount that they can use to file what's called a petition. They'll take a look at the cards to make sure they're valid, and then the employee and the union rather and the company
Yeah.
then essentially negotiate over the details of the election. Things like when it's going to be held, who gets to vote,
Hmm.
uh, what are the polling places, date of the election, that kind of thing. And then you have an election within about 24 days now under the
Not 14 or 15 months later.
not 14 or 15 months. That's not really how it works. In fact, the board issued new rules a few years ago
Yeah.
intentionally to shorten the time period from the filing of a petition to the election date. But in this instance, and how this all got started is this thing that keeps being referred to as a neutrality agreement.
Hmm.
It's really a clause.
Yeah, explain that a little bit, because I don't think a lot of people would quite understand exactly what was entailed in the neutrality agreement between ArcelorMittal and USW.
Yeah, and it's confusing.
Yeah.
So the so-called neutrality agreement is really just a clause that is in a much larger agreement or contract between ArcelorMittal USA and the Steelworkers Union.
Yeah.
It's their collective bargaining agreement. I think they refer to it as a basic labor agreement. It's the kind of contract that if the union were to come into your plant, that they would try to negotiate on behalf of the steelworkers there at Calvert. Now, interestingly, this agreement at ArcelorMittal USA, and keep in mind, are you employed by ArcelorMittal USA?
No.
No. Who are you employed by?
M&S Calvert.
So that's an interesting question right there. How in the world did this agreement and in the portion of the agreement for neutrality get applied to AM/NS Calvert? Now, I don't really have a good answer for that. If you may be interested in asking that question.
I would assume just because we're a sister company and they handle the, my understanding being that ArcelorMittal handles the organizational part of it, the executive part of it. And so from what they explained in our meetings was that's the reason why they were kind of sort of held to that standard. And so our company was like, okay, well, we're going to do the best we can to abide by this. Since we're the executive part of the mill, we're just going to follow what it is that we're supposed to do, because they own half of the company. So, and that's the reason why they were, from what was told to us and what I've gathered, that's how I viewed it.
Well, that's about as good as explanation as I've ever heard, because
that's in my own words. So I mean, from what I have heard from the meetings and stuff that we've had.
So apparently, AM/NS Calvert was essentially treated as the quote-unquote company under this basic labor agreement that ArcelorMittal USA and the steelworkers that was negotiated. And by the way, this agreement is 154 pages long. 154 pages long. How would you like to have a 154-page document to govern?
I didn't like reading it. I read it. I went through it letter for letter, and I read it, and it's a boring read, but I can't. It's very, very shifty. You can tell how much of their tentacles that the USW gets into the company in itself and what they do. Regardless of whether or not the employee knows it or not, they dig into and take part of the company.
Right.
As far as in partnership, I believe they're allowed on the board, if I'm not mistaken. I believe they have some influence on the board from what I could read in there. Like they can't share off shares and stuff like that,
I don't know about that.
But
the very second article in the contract you should take note of. It's titled Union Security.
Yeah.
Not employee security.
No, union security.
Not
for the USW.
Right. Yeah. Not Austin Siemens security, not anybody else's security, union security.
Yeah.
And so in that article, therein lies the so-called neutrality agreement. And in that neutrality agreement, it does a number of things. So your typical neutrality agreement between a company and a union says that the company will not express any position on the unionization of the plant. That's not super common, but it's not unheard of. That companies will enter into those agreements.
Right.
But that's not all that this particular agreement that was applied to your plant says. It doesn't just say that the company will remain neutral. It goes further.
Third party.
It says that the union will have access to the plant, just as you experienced last year. That is highly unusual. You don't see that very much. In fact, I can only think of one other instance in my career that I'm aware of in which union organizers were allowed to have essentially unfettered plant access. Now, they weren't allowed in production areas, but
obviously, for safety reasons.
For safety reasons, but they were allowed to come on site.
Yeah.
The only other time I've ever heard of that is if anybody's interested in labor history, the 2014 Volkswagen UAW campaign in Chattanooga, Tennessee. Organizers were allowed on the plant site, but that was a vote. That was not a card check like you had here,
right?
Or purported to have here.
Right. Right.
talk about that in a minute.
Yeah.
And of course, as you may recall, in 2014, the UAW lost that election. So, but organizers went out on the plant site. So you've got the neutrality agreement, which says the company will not take a position on union organizing. You've got union organizer access to the plant. And then the third prong of this, union security clause, because remember, we want to make sure the union is secure and comfortable
Right.
at all given times.
Right.
Then you get the card check, which means they don't actually have to have a secret ballot vote. Now that's important, because think about, and you experienced this yourself, think about having 90 days, and in your case it got extended to 180 days of time in which union organizers are in the plant, and then their supporters inside the plant have that long a period of time to persuade, cajole, perhaps even threaten in some cases.
Some cases, yeah. There's been cases and talks of other employees that I've spoken with that were intimidation and stuff like that, coercion.
People into signing a card.
Yeah.
And it's one thing to have a card in front of you when your coworker, your peers, some of your union organizers sitting there in your break room for 6 months straight. They're begging you to sign it. And it's another to be able to go inside a voting booth on your own, privately, and cast a ballot that nobody knows how you voted unless you tell them.
Yeah, unless you tell them, yeah.
And, I mean, I'm not encouraging anybody to lie, but you don't have to necessarily tell them exactly how you voted.
Right.
So
it's a lot more freeing to be able to do something like that versus being able to have somebody lord over you and like, dude, you need to sign this. Seriously, it's in your best interest to sign this card. And I've been told multiple stories like that, or it's like, I'm not going to help you. Maybe if you sign a card, I'll help you out, but I mean, I'm just repeating from what stories that I've heard.
Yeah, I don't doubt it.
It's just ridiculous. So
I don't doubt it. That kind of stuff seems to go on quite a lot. So to be clear, just FYI for anybody who's listening, if you have signed a union card in the past, you can vote in this election however you want to. If you sign a card, you're not bound to vote yes. I don't care what some union organizer tells you. You can go in there and vote no.
Right.
Those cards, as we sit here today,
are invalid.
Are useless. They are meaningless.
And I absolutely love it too.
Right. So that kind of segues into another part of how we got here.
Yeah, about how we got here. Yeah, for sure.
So a quick history, I guess perhaps for maybe some new employees who didn't live through this last year.
Right.
So you had the union come in and start their card signing campaign in January. It seemed like it probably wasn't going very well for them.
Arbitration.
Their deadline to get the cards was essentially the end of March of 2019.
Yeah.
They would have had to have gotten a majority of cards signed by that time. So they invoked arbitration under this basic labor agreement.
Yeah.
And which is when the arbitration is part of the neutrality clause. And so they get this arbitrator out in Indiana, a guy named David Diltz, who's not a lawyer, by the way. And Mr. Diltz rules in the union's favor and says, okay, you get 90 more days.
Right.
And it goes on further to declare the employees of the company who were opposing the union as third parties.
Those of us, like, of the Right to Vote Committee.
Yeah. Austin, did you know you were a third party at your own company?
I didn't know I was a third party.
Yeah, I didn't realize that either. But Mr. Diltz apparently thought you are, or thinks you are.
Well, that's been their whole thing. They haven't wanted any of us to stand up and oppose them anyway.
No, because that's the whole point of this neutrality agreement that has that essentially silences the company, ties their hands, gives them unfettered access to the plant, and gives them a card check. It is the labor law equivalent of rolling out the red carpet for the union.
Yeah.
There is no easier way to do this.
Kings.
Yes.
Absolutely. And
I suppose there's
silence you peasants.
Yes. I mean, an employer has to have, they can recognize them, I suppose, but that's very unusual. They can recognize them without a showing of interest, but that's very unusual.
That wasn't in this case, though.
No. And so he rolls out the red carpet for the union. They show up and they find out, oh, my goodness, there's some employees here in South Alabama that don't really care for the Steelworkers Union from Indiana and Philadelphia and Pittsburgh and so on and so forth. And I think they were pretty stunned by it. And so they go get this arbitrator to essentially silence the employees as if they were third parties. In fact, the order from the arbitrator says in black and white that There's, employees and other third parties are not to present a case in opposition to the union inside the plant. So essentially, employees were according to the arbitrator Dilts anyway, restricted to just doing things off-site, like the Facebook page that you've been running and others have been running.
And the secret sticker and T-shirt campaign that we had going on.
Right.
To show support.
And
with our minimum budget.
So after that order comes out, the committee's efforts or activities get curtailed a good bit, unlawfully in the committee's opinion, and there's an unfair labor practice charge pending about that. I guess we can talk about that in a minute.
Yeah.
And then the union proceeds to go back to their card signing campaign, and they assert anyway that by the end of July, the second 90-day period, so now we're 6 months, 2 90-day periods, we're 6 months into this card signing campaign, they claim to have a majority of signatures and turn that in. And there's some employee that I know that had collected, he and his fellow brethren and sisters had collected a majority of signatures on a thing called a petition against union representation.
I think that was us.
I think that was you and some other folks. It
was several of us. Yeah, that did it. Absolutely
incredible work. Really, kind of unheard of. I'm not saying it hasn't happened before, but it's pretty rare
to stop them in their tracks like we did.
Right, and so this petition against union representation gets handed in with a verified, authenticated majority of employee signatures on it the day after the union claims that they've got their cards. And just by the way, if anybody's wondering, so these cards that the union claims that they got signed, they've never been counted, they've never been verified, they've never been the signatures on them have never been authenticated. I'm assuming they're sitting in some taped up box in the union hall somewhere or up in Indiana. I don't know. It doesn't matter. They might as well just.
They definitely ain't giving it back to you, even if you send a revocation letter in that we had made up.
I'm glad you mentioned that. So there were a bunch of people last year.
I have had many people ask me, it's like, where's my card, man? Like, I sent in my revocation letter, and I still haven't got my card back. And I was like, you ain't getting that card back. I'm sorry.
Yeah, no.
They're not giving that back. They're holding that thing hostage.
Right. So I'm aware of a number of people, quite a lot actually, who signed revocation letters, sent them in, and they might as well have just filed them in the trash can because
sending a letter to Santa.
Yeah. Yeah. Dear Santa, please send my union card back. That would have been just as effective.
Oh, right.
So that didn't happen. In fact, it's very possible that some of those revoked cards are sitting in that box somewhere.
Who knows?
With the cards that the union claims they have. And so when this petition against union representation gets handed into the company, of course that caused some confusion, I'm sure, on the company's behalf. So, they've got the union saying they've got cards on one hand, they're signed, and then you got this petition against union representation on the other, and which raises the possibility of there being people who signed both union cards and the petition against union representation. Because at this point, it had gone on for so long, 6 months. You could have employee Joe Smith who signed a union card at some point.
Doesn't even work there anymore.
Well, it could have signed a union card at one time and then signed a petition against union representation on the other. And so there was a process proposed to the union by which this confusion could be sorted out such that the dual signers, as you would call them, would be contacted by whoever's counting the cards and say, hey, Joe Smith, you signed both a union card and a petition against union representation. Would you mind clarifying for me what your true intent is?
Right.
The union rejected that. They wouldn't do that. They were, for whatever reason, they didn't like that. They just wanted the cards to be counted. And remember last year, what was the union saying about that petition against union representation?
It was invalid. It wasn't worth the paper that was that was printed on, and the right to vote committee was essentially not important, so.
Right. The petition was useless and meaningless within the context of this. Well,
that forced the company to have to file for the RM petition.
So thankfully, management, in my humble opinion, did the right thing with that confusion in front of them, and
I know I was happy to hear about it.
Filed what's called an RM petition. So that's also a petition for an election, just like when a union files a petition, except this time it's the management, it's the company filing the petition.
Right.
So,
right, not the union.
Yeah. So the thumbnail sketch of that is if a company has some doubt about who represents or who has a legitimate right to represent or not represent their employees, they can file an RM petition. Yet again, another very odd, unusual thing.
Right.
In the course of this campaign, that's a rarity. Now, I'm not saying RM petitions don't get filed. You can get on the National Labor Relations Board website and see that there's a number of them filed a year. But I believe on average there's less than 100 of them in the country filed annually.
Crazy. I didn't know that.
So, as opposed to several, usually several thousand R cases that are filed by unions. So you get this RM petition. So good news, right? You're going to have an election. The company has filed a petition for election. You're going to have an election.
They posted it in the break rooms, told us to disperse it out into the mill. It needed to all be in areas where visible, where people can see it, and so on and so forth. And then we're told that it's blocked.
And who blocked it?
USW.
The union blocked it.
Yeah.
The union has done everything within its power to prevent employees at AM&S Calvert from ever being able to walk in that ballot box
and cast a vote.
It has been quite astonishing. Usually unions are fighting to have votes. That's another odd thing about this. Unions love to have elections. They collect the cards, file petitions, and then you get a campaign that nowadays lasts about 3 to 4 weeks. Used to last about 6 weeks, and then you get to vote. Unions fought that tooth and nail in this case.
Yeah, they were supposed to. I think they added the blocking charge from what I've been able to see in court filings that I looked on my own, that I could see where it was actually blocked like the very day of the actual pre-election hearing, because we actually were going to have a pre-election hearing in August, and then we were supposed to be voting in August. It's like 23 days from when the petition's notified that we're supposed to be able to vote, and they blocked it just like they did here recently.
Right. So you had that block on the RM petition back in August or September. I don't have a timeline in front of me, but that's roughly accurate. And so this unfair labor practice charge then gets investigated by the National Labor Relations Board, Region 15 in New Orleans, which they have to do. Right. And so they investigate some more, and I'm assuming they interviewed a bunch of people.
I don't know.
And then meanwhile, you get some other unfair labor practice charges filed. One, which is still pending, deals with the neutrality agreement itself and its, in the committee's opinion, unlawfulness.
Right.
In that it infringes upon employees' rights to engage or refrain from engaging in union activity.
Section 7.
Section 7. So I didn't want to get too technical on this, but there's a part of the National Labor Relations Act. Which guarantees employees the freedom to engage in what's called concerted protected activity, i.e. support a union or refrain. Now, normally, most of the charges in the litigation deals with employees' rights to engage in union activity. There's not a lot out there about employees' rights to refrain or oppose, but it's there.
Yeah.
And so that's what the charge says. It also more than claims. I mean, it asserts that this whole neutrality agreement was a thing of value given by the company to the union, which is not lawful, meaning that this basic labor agreement and its neutrality provisions, which include the car check, the union organizing access, and the neutrality stance, was a thing of value given to the union. Hard, in my opinion, to refute that. I mean, ask any union organizer, how valuable is it to you to be able to have plant access for 3 months straight in your organizing activities? They'd say that's pretty darn valuable.
Yeah.
And then there's this other thing that happened last summer, which is extremely strange. And so if you're a specialist or planner and you're listening to us, me and Austin here today, I want you to listen to this real carefully. So last summer, there was a dispute, and you probably are aware of it because it's ongoing here today.
Yeah, I've got it posted on our Facebook page.
Good.
Yeah.
You guys have done a great job with that
Thanks.
Facebook page.
Appreciate it.
I mean, the amount of research and the time that you all have put into that, I mean, it's amazing.
I don't. Yeah, we'll go on from that.
So so there was this dispute, which is ongoing today, about whether specialists and planners would be in the union or out of the union. And then today, it's more about whether they can vote or not.
Right.
But it's essentially the same issue. Are they in the bargaining unit or are they not? And so last summer, the union took the position, and it was documented in this thing that was called a settlement agreement, that said that for the purposes of the card check that was going on last summer, the specialists and planners would not have their cards counted. In other words, they wouldn't have a say-so as to whether the union would be in the plant or not.
Correct.
And so to the extent any specialists or planners signed any cards, they wouldn't be counted. But, and this is a big but, over time, the agreement said that over time, as those positions became available, the work being done by them would be added into the bargaining unit. In other words, the work being done by those specialists and planners would become bargaining unit work, likely hourly rate type work, because I think specialists and planners are mostly on salary.
Yeah.
And so, but then they'd become hourly rate, and they'd be in the bargaining unit.
Correct.
Represented by the union. So that's a long
Without
way.
ever having a chance to vote on having their voices heard. Period.
Right.
Yeah.
So that's a long way of saying the union last summer had no interest in the specialists and planners cards being counted, but they sure wanted that work.
Mm-hmm.
They didn't want the specialists and planners. They didn't want the people in those positions because, frankly, they know most of those folks are not for the union. Let's be honest.
Yeah.
But they wanted that work because they need the dues money, and the more people you got in the union, the more the more money you get. That's pretty obvious.
Right.
Now, fast forward to today. So now it's not about counting cards; it's about counting votes. And before you can count a vote has to be cast. And the union does not want specialists and planners to vote. But yet again, I mean, so what does that mean? Does this settlement agreement still hold? So that if the union wins the election, this work being done by specialists and planners gets added to the unit, or what's called accreted into the unit.
Now, is that normal? Have you seen that before?
No, this isn't normal.
Oh,
it's very odd.
I kind of assumed that this was like normal. That
Oh, no.
No, absolutely not.
No. I mean, it which brings us full circle, I guess, to the earlier point, which is one of the other unfair labor practice charges that the committee filed alleged or asserts that this settlement agreement about the specialists and planners last year was unlawful pre-recognition bargaining.
Right.
And what that means is, the company and the union cannot lawfully negotiate and bargain over terms and conditions of employment without the union actually representing anybody.
Yeah.
And they don't represent anybody at AM&S Calvert right now.
No.
They don't represent anybody. They don't represent you or anybody else.
Nope.
Even a union supporter. If you sign
Right.
a union card,
You're still not being represented by
yeah, they don't have the power to negotiate
Save my
anything. on your
job or
behalf.
any of that stuff.
No.
No.
Until they get certified as the exclusive bargaining agent
Correct.
by
That's
the
the
National.
important part. It's certified.
Yes, they got to be certified. So until they get that certification, it is unlawful for the company and the union to negotiate over terms and conditions of employment. So the charge asserts that this deal, and I'll call it an unholy deal, that was struck last summer over the specialists and planners, not counting their cards but getting their work in the bargaining unit eventually,
Yeah.
was pre-recognition bargaining. So those charges are pending with the National Labor Relations Board even to this day. The board is looking at them very carefully. I want to be careful about how I say this. I am optimistic.
Yeah.
I, personally, Tom Scroggins,
Yeah.
am optimistic that the board will find merit to these charges and issue a complaint against the union and the company based on these charges. Now,
Yeah.
do I expect that? Do I know that? I don't know that for a fact,
But you're optimistic.
I am optimistic.
Well, that's good. I don't think you would have. I don't think you would have taken the right to vote committee's complaint and filed it if you didn't see that it warranted, being filed.
Right, and I'll add in that on a broader scale, it appears to me that the board is taking a closer look at neutrality agreements as a whole, and I don't mean neutrality agreements in the context of your plant. I mean neutrality agreements as negotiated by unions and companies across the nation.
Across the nation, yeah.
And because there are some problems with them, in my opinion, because again, while they're just called neutrality agreements, there's a lot of these agreements have a lot more to them, just like the ones at issue in your plant.
That had hidden language in it and stuff that allowed them unfettered access to our facilities, so
Right.
on and so forth. So
Right. Stuff that in reality, I think chills employees' ability to make an informed personal decision about whether they want a union to represent them or
Correct.
not. And let's be clear, whether union, non-union, whatever, the National Labor Relations Act and the National Labor Relations Board essentially exist to create an atmosphere in which employees can freely choose whether they want union representation or not.
Right.
Now, when you get into these campaigns, both sides, it's almost like a political campaign.
Yes. That's what it feels like, for sure.
Yes. I mean, we're in Alabama, so you feel like you're being asked to vote for Doug Jones or
Terry Tuberville.
or Tommy Tuberville or
Yeah,
Jeff
Tommy
Sessions. I don't want to denigrate Jeff Sessions. He may win.
I'm not an Auburn fan, so I don't know.
Right. So
Roll Tide.
Go Tigers.
All right.
So it's like you're being asked to vote for one, and they're going to fight, and they'll be campaigning on both sides, and you guys are going to express your opinion. Thank God, by the way.
Yes, yeah, and honestly, regardless if they were going to continue to try to strike us down and keep us from being able to openly voice our opinions and oppose them openly, we were going to do it anyway. We didn't care. I mean, there was enough of us that were just like, you're backing me, I'm backing you. This is not right. We're going to fight them tooth and nail. And so we've managed to be able to do that to get us to where we are today.
Yeah, I have been astonished at how many and how solid this group of employees has been. The Right to Vote committee. I think a lot of people were very upset that they were initially told they wouldn't be able to vote, which seemed wrong to them.
Right.
And then you fast forward. Here we are a year later, and you get a vote, and I think a lot of people feel like the union has not really been upfront with them about a lot of things.
Yeah, absolutely. They have not told any of their supporters during their campaign about what was going on, what essentially why they weren't being able to get the vote, or why their card check process that was supposedly counted as a vote. Because a lot of the people that I spoke to that signed cards are like, well, yeah, I've already voted. I was like, no, you haven't voted. And I don't know who told you that or lied to you and told you that, but that does not count as a vote. And it's very, very important that you realize this. So the education on it, because the company couldn't even educate them on that, because they were silent. So then it was left up to those of us in the Right to Vote committee to be able to actually go out or post on the Facebook page and explain these things, And thankfully, we've been able to get a good following and be able to get that message out to show the employees at A&S Calvert that, listen, I mean, it's, some of these things, if not all of them, that they're trying to tell you is to only try to use you as pawns so that way they can get in here and essentially get to our mill. They're going to say and they're going to do whatever they possibly can and promise you whatever plan that they can get you, tailor make it. But when the time comes, it's not going to be what they promised to begin with. It's going to come up short. So
that brings up an interesting point in the context of these campaigns. The union can promise you and your fellow coworkers anything. They could promise you that you're going to work one day a week, and on the other 4 you're going to ride rainbows and unicorns.
Yeah,
they can tell you that. They can promise you that. But in reality, if they were to win the election, what they get is the ability to sit at a table not unlike the one that we're sitting at here today, and ask the company to accede to their demands.
And I want to touch on that next time with the next question here. So
right.
We're going to go from there.
Sure.
Thanks for listening. Please comment below, like, follow, and share. If you have any questions, feel free to message us. And remember, the vote no equals freedom.